Welcome once again to Lehto's Law. Here's Steve Lehto.
I got a note from Jimmy, who's in Australia, and he said, Steve, I'm fascinated by the American legal system. I'm curious. I found a case that seems odd to me. At least it sounds odd to my way of thinking because I'm in Australia. He goes, is this common how the U.S. legal system is? Is the story I'm sending you the link to something that could commonly happen in America? Is this an American thing or is this an anomaly? And so, Jimmy, I'm going to tell you that this is something that could happen in America quite easily in another case. But we'll talk about that at the end. But from the Huffington Post, Dave Jamieson wrote the story. Starbucks tries to slow union elections but misses legal deadline by 8 minutes. So what we're going to talk about here is the fact that there was an entity involved in a legal dispute that was supposed to file a response by a particular date and time. And the court said, if you want to respond to this, you must respond by this date and this time on that date. They attempted to file their response at the last minute, and they failed because they claimed they had some kind of software mix-up. And as a result of that, they filed their response 8 minutes late. And the court looked at it and said, well, you missed your deadline. You're out. So the coffee chain's legal team said that their Microsoft Outlook crashed as it was emailing the files. A labor board official didn't have much sympathy. So there are workers at Starbucks wanting to unionize. Starbucks has used a massive legal team to slow the pace of the union elections, but the coffee chain suffered a tough legal setback on Friday thanks to some late emails. Workers at several stores in upstate New York recently petitioned for union elections, just like 2 stores in the Buffalo area that successfully unionized last year. Starbucks, through its lawyers, has asked the National Labor Relations Board, of the NLRB, not to move ahead with the votes, arguing that elections for individual stores aren't appropriate. The company wants all the stores within the region grouped into one big vote. With dozens of stores around the country looking to join the union, Workers United, that argument has slowed down the legal process and bought Starbucks more time to run its campaign to try to discourage workers from joining the union. The strategy, however, hit a snag when Microsoft Outlook apparently crashed on one of the Starbucks lawyers' computers. In order to make its case for the bigger union election, Starbucks had to submit what's known as a statement of position to the labor board and the union by noon February 11th. So the court said if you want to respond, you've got to file your petition by February 11th at noon, okay? And of course, I'm talking about the labor board. It's not technically a court, but I'm going to use court as the catch-all here as to the tribunal that you're in front of. The company's lawyers didn't get all the paperwork to the union's lawyers until 12:08. 12:08. A lawyer for the law firm explained the mishap in a filing to the labor board, saying the files attached to the emails were apparently too large. Your email is too large. You've got mail. Just before noon, counsel attempted to send the complete service email a second time, but was again prevented from doing so when Outlook crashed again. He was thwarted by his email program. A Buffalo-based labor lawyer working for Workers United argued in a filing that Starbucks should not be allowed to make its case because of the blown deadline. Starbucks argued in response that the union suffered no prejudice as a result of the small delay. So you got it after lunch instead of before. What's the difference? An official with the labor board sided with the union on Friday. Having carefully considered the matter, I find that the employer's failure to timely serve its statement of position precludes it from litigating any of the issues raised in its untimely submission. That's a Labor Relations Board regional director writing in an order in response to the request to allow them to file this late. Starbucks had to submit what's known as a statement of position to the labor board and the union by noon on February 11th. The company's lawyers apparently didn't get the paperwork to the union lawyers until 12:08. If Starbucks lawyers had sent the statement out on time, it could have easily added weeks to the timeline for elections at the New York stores. Delaying elections allows employers more time to persuade workers to vote against the union. Starbucks can appeal the order from the NLRB by asking the labor board in Washington to review it. So there is an appeal process here. The legal tussle over the missed deadline is the latest indication of how the gloves have come off between Starbucks and the union. And it goes on and on about how they've gone back and forth on this. And the unionization of Starbucks is not what I want to talk about here. Among other things, I'm not a big coffee drinker. And I don't think I've set foot in a Starbucks in 4 or 5 years. And even then, I was with somebody else who drank coffee. And I didn't get anything. So I don't have a dog in this fight, as they say. However, what we're talking about here is that the court or the tribunal or the board said, you must file something by this time. If you do not file it by this time, you are waiving your right to respond. And that's common in courts. And that's common in courts everywhere, not just America. I'm pretty sure that England and Australia have courts that have filing deadlines. You got to file something. The question is, how harsh are those deadlines? How harsh are the responses from the courts when you miss a deadline? And I'll give you the most common example I've talked about before. If you get served with a summons and complaint and you're being sued, the summons says right on it, you have 21 days to respond to this complaint, 28 days if served by mail. So you look at it, you just got handed this thing by a process server, and you got handed it right now. You've got 21 days to file an answer. And it says right in the summons, if you do not file in 21 days, you may be defaulted. Well, you will be defaulted, most likely. And so what happens then is the attorney that was working for the people who sued you will mark on their calendar that, okay, we got good service from this person on this date, and then here's 21 days later. They'll check the files to see if they got an answer. If they didn't get an answer, they can go into court and get a default. Say this person did not answer timely. I've defaulted a couple dozen people in 30 years of practice. And most of the time, an attorney shows up and says, hey, I just got hired by this person that your client is suing, and they didn't respond to the complaint in time. Have you defaulted them yet? And nowadays they'll know because they can go online and look it up. And I'll say, yes, I have. They say, oh, well, you set it aside. And now the court has rules on how all of this works. And the parties can agree to set something aside, and the court will almost always go along with that. But I've had people call me that and I say, why did they not respond? And I've had someone go, oh, they weren't served. They weren't served. And I've had someone say it to me when I personally served the defendant. And and as an attorney, I'm allowed to serve people. And I actually called my process server and go, I need somebody to serve him. The guy goes, I'm really busy. I can't get to it till next week. And I go, I want to serve him now. So I just grabbed summons and complaint, drove over where I knew the guy was, and served him myself. And 25 days later, an attorney calls me and goes, well, there was no good service. And I go, yeah, there was. The guy goes, how do you know? I go, I served him myself. The point is that if someone gets served, they get 21 days to answer, right? Serve person, 21 days. So if I agree to set it aside, which I've done many times, but I'm not going to set it aside when somebody goes, oh, they weren't served, when I go, I'm the one who served them. Come up with something better than that. But I've also had somebody who I served them, defaulted them, had a hearing on damages, got a judgment. The time for appeal of the judgment lapsed, even though I served the judgment on them. And then I've had them call me up and say, Steve, will you set all of that aside? Set the judgment aside, set the default aside, and we'll start over from square one. And I again will ask and say, why did your client not answer the complaint and not respond to the motion I filed for entry of judgment? What's going on? And I've actually had an attorney go, I don't know, the guy just called me now. At which point I'm like, okay, if you want to set it aside, you have to pay us a couple $1,000s for all the legal fees we wasted on this. Oh, no, we're not going to do that. Well, interestingly, the court rules talk about what happens when the court sets something aside. And one thing they'll often do is they'll ask, were the parties prejudiced by this? Did it actually harm a party? Also, did it cost a party anything? And so in the situation of a default, where a default gets set aside, the court rules say that the court can set aside a default after a hearing where they find there was good cause as to why the person didn't respond in time, and order the party asking for the default to be set aside to pay the costs of the other side because they ran up costs. And it would be stupid to say you can come into court late, get it all set aside, and you have no penalties. So you look at the different rules that govern these different arenas. And I'm not familiar with the rules that govern the NLRB, but I suspect that they're very similar to court rules in that they say, here is how the times work, here is how the deadlines work. And if a deadline is blown, here's what happens. And by the way, if if somebody comes into the board and asks for something to be set aside, here are the conditions for which it can be set aside. And if it's set aside, here's how you do that, and here's what happens. And if you don't set it aside, here's what happens. And then, of course, they can always appeal that stuff. And I actually, in one of the most wasteful cases I was ever involved in, it wasn't waste on my part, it was waste on my opponent's part. But I had a case where I got a default against somebody. And they didn't respond, so I defaulted them. I then got a hearing for an entry of a judgment, served them with that, they didn't show up. Got a judgment against them, served that on them, they didn't respond to it. The time passed for them to pay the judgment, so I started doing execution on the judgment. Suddenly they hire an attorney. And the guy calls me and goes, will you set all this stuff aside? And I go, why'd your client ignore everything? He goes, he's busy, lost it, the sun was in his eyes, that kind of thing. And I go, no, I'm not going to set this aside. It's crazy. Your client could have responded 16 different times and they missed it. And so the guy goes into court, the attorney goes into court and brings a motion to set it all aside. And the trial court that we're in front of originally says the same thing I did. Where was your guy before? Why do you ignore all this stuff? And the guy wasn't arguing and saying we were never served anything. He admitted it. We were served with everything. We were served with everything. And so the guy appealed that. They appealed that ruling up one level to the next level of court. And that court actually said, well, Mr. Lehto, why don't you want this guy to have his day in court? And I said, it's not that I don't want him to have his day in court. It's that he had several opportunities. He chose not to take them. And the judge goes, I can't see how this could possibly hurt somebody to give them their day in court. So I'm going to reverse this. I said, okay. I appealed that to the Michigan Court of Appeals, who spun it around and said, no, you don't reverse that. You let it stand. So it's crazy how this stuff happens. And some people will look at our legal system and go, Steve, these rules where like you miss a deadline by 8 minutes, that's crazy. Well, you know something? There are attorneys from a very large law firm, by the way, who represent the side that missed that deadline by 8 minutes. And they've got floors of attorneys in big buildings with like mirrored windows on the building, okay? The budget for watering the plants in that office would be enough to hire 10 more attorneys. Okay, that's how big the law firm is. And they missed a deadline by 8 minutes. And their excuse is, our email crashed, okay? I assure you there are people there who would have thought, we should file this maybe a half hour early, just to be on the safe side. And these kind of screw-ups don't normally happen at this level. That's why it's making the news. But the question is, if it's 8 minutes, and that's something we can forgive, what about 10 minutes? Half hour? 45 minutes? Hour and a half? A fortnight? And so you understand that there's an argument to be made that you've got these deadlines. Everyone knows about the deadlines. We're all playing by the same rules. And by the way, if the union had blown a deadline by 8 minutes, do you think big law firm would go into court and say, that's okay, Your Honor. We're cool with that. Oh, no. Oh, no. So one of the first arguments that I like to have people ask themselves rhetorically, when you're processing something and you're going, this is unfair, ask yourself what would happen if it was the other way around. Do you think that the attorneys for Starbucks would have said, oh, they blew a deadline by 8 minutes? Not a problem. I guarantee you they'd be drafting briefs this thick explaining how that 8 minutes was so vitally important that it completely would upend time, space, and dimension if we let them slide on that. Okay? So the deadlines are there. They're usually strictly enforced, but there's almost always a mechanism whereby you can ask for the rule to be relaxed or overlooked for a good reason. And the question simply becomes then, what is a good reason? Is the fact that your email crashed because you're trying to send something with too large of an attachment a good reason? I don't know. It's hard to say. I know what the size limits are on attachments on my email system, but it doesn't crash the system. It simply kicks back a thing saying that email's too large. You've got to take these attachments off of it. But beyond that, so we'll see what happens, because I suspect they will appeal this to a higher authority. We'll see if it gets overturned. But as of right now, Starbucks is kind of, out because they missed a legal deadline by 8 minutes. And yeah, things like that do happen in court. They just don't normally make headlines. So Dave Jamieson wrote it, Huffington Post published it, and Jimmy sent it. Thanks a lot, Jimmy. And he asked, is this just an American thing? Well, it seems like it, but not necessarily. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. It is one thing to decide to climb a mountain, and it's quite another to be on top of it.